Today we're going to be discussing the drafting of wills, trusts, and estates, which we commonly refer to as the planning aspect of wills, trusts, and estates. First, we'll be discussing the last will and testament. A last will and testament, in addition to describing where a person's assets should go when they pass, can also be used to ensure that a minor who inherits property does not squander the property, can be used to ensure that a disabled child would receive the benefits of inheritance without losing their benefits, which are typically Medicaid, Social Security, and can also be used to nominate a guardian for any minor children that may be around when the person passes. Besides the transfer of assets upon passing, we'll first discuss which I like to refer to as a minor's trust. A minor's trust is actually a trust which is drafted into the last will and testament itself. Minor's trusts are used for when a person has a child who typically is younger than age 30. So many people, when they meet with me, might say that I have a child who is 21 years old. And if I were to die today, I would certainly want to leave that child an inheritance. However, I do not feel it's appropriate that child would receive their inheritance outright, because they would spend it on something which would be ill-advised. For these clients, the minor's trust is the perfect tool to draft into a last will and testament. The minor's trust is a trust whereby a client would set a specified age for the child to receive the inheritance outright. This can either be one age, for example, at age 30, the child would receive their inheritance outright, or we could ladder the ages. So for a 21-year-old child, we could say the child would receive 1/3 of their inheritance at age 25, 1/3 at age 30, and the last third at age 35. With these trusts, once you specify an age for distribution, for example, the child will receive all their assets once they turn age 30. On the happening of that event, which is the child's 30th birthday in this example, the trust would terminate and the assets would pass to the child outright, and the child would have absolute freedom to do whatever they want with those assets. However, before turning the pre-specified age or ages, the trustee of the trust is able to make distributions from the trust for the benefit of the child, such as paying for the child's college, paying for the child's education, purchasing a house for the child, or paying for the marriage of a child. It is up to the trustee to use their discretion in making distributions prior to pre-specified ages. The second aspect, or the second trust which can be built into a last will and testament, is a supplemental needs trust. A supplemental needs trust is an important planning tool, not only for clients with disabled children, but all clients. Because heaven forbid something should happen to a well child, it's important that their inheritance not pass them outright, but go into a supplemental needs trust. Drafting a supplemental needs trust into a will is a way to ensure that any disabled child would receive their inheritance in the supplemental needs trust outright. If a disabled child were to receive an inheritance outright, they would lose any government benefits they're currently on, such as Medicaid or Social Security, and that child would be forced to spend their inheritance all the way down to zero before they would qualify for those programs again. So in essence, the inheritance would be squandered or wasted. By employing a supplemental needs trust, the inheritance which was to go to this child will instead be held and managed by a trustee. This trustee will have authority to make distributions not directly to the child, but to purchase certain things for the child so their life is enhanced. And none of these purchases by the trustee would disqualify the child for their current government benefits. The other benefit of a supplemental needs trust is the client could specify who the supplemental needs trust will ultimately be distributed to upon the disabled child's passing. This is a tremendous benefit because the trust can be used to ensure the child receives a better life, an enhanced lifestyle while with us. And once they're no longer with us, the remainder of the trust, which is usually substantial, will pass to children who are not disabled outright. The third thing, which is important to consider when drafting a last will and testament, is the nomination of a guardian for a minor child. In this instance, a minor child is a child who is under age 18. Many younger people will come to me with very young children, and sometimes their primary goal in drafting a last will and testament is not truly to state who their inheritance should pass to when they die, but to ensure that the appropriate people are appointed by the court to care for their children and to ensure their children's finances are looked after. Oftentimes, clients will come to me and they will say they prefer one set of grandparents to care for the child as opposed to the other set of grandparents. By drafting an appropriate last will and testament which nominates the more appropriate grandparents as the guardian, the client can rest assured that the court will most likely appoint these grandparents as the appropriate guardians to care for the child. But the primary trusts that we deal with at C. Hainer Law are the Medicaid Asset Protection Trusts. These trusts are designed so a client can deposit large sums of assets into this Medicaid Asset Protection Trust. And by doing so, they can rest assured that if they ever needed Medicaid benefits to pay for their costs of long-term care in the future, they would more easily qualify for the Medicaid program. Essentially, the client would make these deposits with the trust, thereby divesting themselves of these assets, and start the clock running on the 5-year look-back period. If a client were to draft a Medicaid Asset Protection Trust and were to deposit certain assets with the Medicaid Asset Protection Trust, if that client were to remain healthy for 5 years, they could rest assured that they would qualify for the Medicaid program if they needed to cover the cost of nursing home care, without the nursing home or the government being able to touch the assets which were deposited into the trust account.